Okay, hi again. Welcome back. Attorney Steve Vondran here. We are talking in this video about how to use the copyright symbol like a pro. Okay, so the copyright symbol, everybody has seen it. It's the C with the circle around it, okay? So everybody has seen that, but not everybody knows what it means, how it works, when you use it, when you don't use it. So let's talk real quick about this. All right, so this video is brought to you by AttorneySteve.com, the first name in legal services. Now, first I'm going to start out with a few myths, okay, a few things that people, they think they know, but they're usually wrong on. One, that you must register your copyright to be able to use the symbol. When I say register your copyright, that means send a picture of your photo or something to the United States Copyright Office, or your song or your video, pay the fee, and get the registration. Some people think you have to do that in order to use the copyright symbol. False. Not true. When you create an original work and you fix it in a tangible medium of expression, it automatically has copyright rights. So a lot of people don't know that. So you don't have to first register your copyright in order to use the C symbol. So if you think you have a great piece of art and you drew something really nice out, or a painting or something, a song, you can put on there with the C without even registering with the United States Copyright Office. That's important to know. But I'm going to talk about in a second the benefits why you would actually want to do that if it's something you really do want to protect and exploit. Myth number two, if there is no symbol on the work, it is not copyrighted. Now, this is the one that we get a lot when we deal with photo infringement cases. Somebody will call us and say, I found this photo on Google Images. There was no copyright symbol, and I'm not paying anything for that. And I say, well, you know, there doesn't have to be a copyright symbol on there. Just because you don't see the symbol does not mean that it's not a copyrighted work. In fact, you should assume the opposite. You should assume that it is a copyrighted work and seek to get permission, or do what I do, go to a commercial photo site and pay for your license so you don't have to worry about it. I mean, you know, who wants to get a copyright infringement notice of infringement in your mailbox or email? Who wants to deal with that? So that's myth number two. Myth number three, if you use the symbol, your work must be subject to copyright. In other words, you may draft a document and you say, this is so creative that I'm going to put a copyright symbol on it and tell the whole world that this is subject to my copyright. Well, the reality is that's good and might work, but a copyright only protects original works of authorship fixed in a tangible medium of expression. Certain functional items are not copyrighted, certain names and slogans and things are not copyrightable. That could be subject to trademark. So just because you see a C symbol or just because you use the C symbol does not mean that you have copyright protection. Okay, those are the three common myths that I run across out there dealing with copyrights. So I have here hashtag copyright myth if you want to share some of those on your Twitter feed. Now, here's what I have as the preferred format. You can see that here. Now, there's really two ways to do it. There's actually more, but two that I think are the best. You can either use the C symbol, as you can see here, copyright 2018, Attorney Steve Media, all rights reserved. That may be something formal that you see. And again, let's talk about it. This C means that you're claiming copyright. So that could be that you're claiming copyright without it being registered. It could also mean that you did register it. So the C is putting the world on notice that you believe that your work is subject to a copyright. That should tell others, I need to license this, or I shouldn't be using this without permission. So the C is the big public notice of that. Now, it's important to know before March 1st, 1989, you didn't need to use the C symbol. Before March 1st, 1989, you did need to use the C symbol in order to claim protection. But post March 1st, 1989, they dispensed with that requirement. So, but the C is there to put people on notice. The year 2018 that you have here, that is the year of the first publication. So you're telling the world, on this date, this document, and let's just say this applies to my blog and my video here. I'm telling everyone, on this date, 2018, my rights in this video is now mine. Attorney Steve Media, all rights are reserved. What's that mean? That means the right to reproduce, make derivative works, publicly display, publicly perform it, they're all reserved to me. So that means if you want any of my rights, my what we call our bundle of rights, you need to come see me and say, hey, Attorney Steve, we want to turn this into a book. We want to turn this into a play. We want to do something great with this. We want to put it in, we want to put your article in our magazine or something. You need to get permission. Okay, now there's another kind of copyright symbol I'll talk about. Well, I'm not going to talk much about it, but it's called the Creative Commons. So if you don't know anything about this, Creative Commons, check out my video, Attorney Steve Creative Commons license, and that will tell you a different type of copyright that you can use, which is becoming popular in what we call our sharing culture, and that's allowing people to use non-commercial uses of my video. If you want to share it on your blog, be my guest. In fact, I really don't care if people want to share my blogs on their social media networks. I'm fine with that. I don't want it to be used commercially in a magazine or a book, something where somebody's putting together my materials. But if they want to post it on their social media blogs, I have no problem with that. I usually tell people in my videos. So at any rate, check out Creative Commons if you want to know a little bit more about the sharing culture and some of the new copyright permissions that are coming out. Okay, so again, let's get back to the preferred format. You got your copyright symbol. You can also use the word copyright if you don't like the symbol, or sometimes you're using a image designer or something and you can't find the symbol, they don't have it. Well, just write the word copyright. That's another way to do it. Those are, to me, the two best ways to do it. There are others, but those are the two that I prefer. Copyright, just write it out, copyright. So you have your copyright notice, you have your year, you have the owner of the copyright, that's Attorney Steve Media. It could be your business, it could be you personally. So whoever owns the media, and a statement that all rights are reserved, or you could put, non-commercial uses are permitted. You could put whatever you want. So you're the holder of the copyright, you own it, you decide how it gets to be used. That's the beauty of it. Okay, so let's talk about, now you know kind of some of the myths, you know what a copyright symbol ought to look like. You can put this in your blogs and your articles. You can put this on your books, your music sheets, your anything that's tangible. You can put your copyright symbol on. Incidentally, a little fun tip: if you're using phono records, what symbol are you going to use? I bet nobody knows. The P with the circle around it is what you use for phono records and sound recordings that are distributed publicly. All right, so let's get down to the benefits. This is it. If you've hung with us this far, we only got a little ways to go. The benefits of formal copyright registration and putting people on notice in this format that we're talking about. One, it allows attorney fees and statutory damages. I spelled damages wrong. Up to $150,000. Now, you may say, well, wait a second, Attorney Steve, that's crazy. You mean if I copyright a photo and somebody uses it in a magazine without my permission, I can seek up to $150,000 in statutory damages? Yes, that's exactly what the copyright law says. Now, that doesn't mean you're going to get that, but that's what the copyright law says. If you can show willful infringement, you can get $30,000 to $150,000 in statutory damages. So again, if you have something really great, that you want to protect or exploit, or send out for licensing, or post a website and say, I've got some great things for licensing, that's why you want to do it. That's why you would pay the $40, $50 to get your copyright registration, and be on your way to have something that you can actually protect in court. So it also allows attorney fees, which is very important. If you get to the point where somebody is infringing, you've got 10 different companies infringing your work, you're going to want to be able to have an attorney take up your case. In that event, it's nice when you can say, Mr. Attorney or Mrs. Attorney, I do have a copyright registration. The attorney's naturally going to go, that's nice. All right, what do you have? Let's see here. Does it meet the requirements? Okay, yes, this looks good. Is it being used commercially? Yes, looks good. You've got your date there. You've got your notice. Wow, we couldn't ask for anything more. And the other nice thing about the notice, well, I'll get to that in a second. But anyway, benefit number one is look at the incredible amount of damages that you can potentially receive if somebody's infringing your work. So that's a big benefit. Number two, a prerequisite to filing lawsuit in federal court. What's that mean? So that means if you do have somebody infringing your work and you eventually want to file a lawsuit, you're going to need to register your copyright in the first place. So, it's always, like I said, it's always good practice if you're an artist, a designer, somebody that does creative works for a living, bands, things like that. You want to get your stuff copyrighted for that reason, okay? Again, number 3 shows the date of first publication, and that will indicate to other people how long your rights are going to expire. At some point, copyrights don't last forever, so they do go into the public domain, usually after the author dies in a period of a certain amount of years need to expire. Once that happens, it goes into the public domain. So by putting the date there, the 2018, people know when it was first published and when your rights might expire. So if it's in the public domain, they may just want to freely use it without getting your permission, okay? So, and the last one, again, puts the world on notice. This is good because there is a defense in copyright law known as innocent infringement. And innocent infringement, while it's not an excuse for infringing, it can mitigate your damages. It could bring it down from that 30 to 150 down to a couple $100, $1,000, couple thousand. But when you have the copyright notice on there and you say, how can you say this was innocent? It had the copyright notice right there. How can you say that? So this will help as a plaintiff, if you're looking for plaintiff counsel to help bring these cases forward. It's going to help to put people on notice so they can't use that innocent infringement defense, okay? So these are some of the basic ideas. We help both plaintiffs and defendants in copyright actions. So if you need some help, you can find us here on the web at attorneysteve.com. I hope this has been a helpful video. This is general legal information only and not legal advice. If you like the video, give me a like, a thumbs up. Better yet, subscribe and join over 5,600 people that love getting our free legal information. And we're happy to have some comments and anything that you want to post in the box, okay? Have a great day. Attorney Steve out. We'll talk again. Bye now.